Hey there, I'm the MadCatster. Am I glad to see you here? Well, SSSniperwolf's unconventional legal team has filed a response to Sausage's opposition to her motion to dismiss. And as you can probably imagine, if you're familiar with what they've filed so far that we've talked about, this goes off into crazy land. And we are going to talk about another installment of Kindergarten Court. I've got the deets and all the receipts, so buckle up and let's go. So first I want to say I'm sorry that it's been almost a couple of weeks since I uploaded my last video. Work has been absolutely insane. As most of you know, I'm a real lawyer, and to give you an idea, last Friday I had 14 cases in the same court all in one day. We're almost to 30,000 subscribers. I'd really like to see us get there by the end of the year. So if you are watching and you are not subscribed, please subscribe so that we can make that goal. I'm here with Cedric because Sybil is upstairs and I'm trying to get her to come down, and she's feeling fine. I don't know what her issue is, but I'm sure she'll come down. And before we get started, I just want to say a couple of quick thank yous. I would like to thank Jacqueline N and her cats Bilbo and Fenny, who sent us some Temptations cat treats. Thank you very much. Along with a thing of lightweight cat litter, which is awesome because we go through something. You can imagine how much litter we go through. And she sent us a couple of packages of the catnip mice, which the cats really love. So thank you so much for your generosity. Also today we got a really nice raised water and food bowl set. Unfortunately, there were no slips at all in the package, so I do not know who sent it. So if you sent it, please contact me. Whoever you are, thank you very much. So we're going to talk about SSSniperwolf and her continuing saga of the lawyers who, I don't know if you've heard of the site Fiverr, where you can get all kinds of little jobs done and for a reasonable fee. Well, in my opinion, it seems like SSSniperwolf got her lawyers from Fiverr because they continue to boggle my mind with the really crazy nonsense that they put into their pleadings, and you're going to see in a second. So what they have filed is basically a response to the opposition to their motion to dismiss that Sausage filed. This is something that does happen in the courts, usually in most states, and I don't know all of the rules in Arizona, but in most states, usually you have to ask the court for permission to file a response to an opposition because understandably, the courts don't want to get bogged down in all kinds of back and forth excess pleadings, but I don't see that they've asked the court's permission. They've filed it anyways. Now, whether we'll get a reply from Sausage's team, but that remains to be seen. We're going to take a look at, they have filed another, what I would call a nursery rhyme pleading, because it's full of all kinds of stuff that honestly I don't think the court's going to appreciate. So let's take a look now at this really ridiculous response from SSSniperwolf's legal team. So you can see here, it says reply, technically it's called a reply, in support of their motion to dismiss. And then if Sausage files a response to this reply, it's called a surreply. Here we go. Buckle up. New York City is a large city in the United States. The moon revolves around the earth. A chicken has 4 legs. And then there's a footnote. And again, it's so absurd. It almost seems surreal to me that it's like a joke. You know what I mean? It doesn't seem real because this is not how you put together a pleading that you file with the court. And the footnote says, obviously a chicken does not have 4 legs, but it took you a second. It didn't take me a second. Don't confuse Young's repeated, and this is the same crap that they keep spewing. Don't confuse Young's repeated statements as truth just because they have some air of familiarity. You mean as in they're based in the law and then they're correct in their assessment of the law as concerns their position? It says most animals have 4 legs, which is why it took you a second. Well, did it fool you? Did you think a chicken had 4 legs for a second? It didn't fool me. Repetition does not equate to reality. Well, someone ought to tell these lawyers that because they keep regurgitating the same crap over and over again, and they want the court to somehow think that for the umpteenth time that they say the same nonsense, that somehow this is true. You know, they don't want the courts paying attention to the legal arguments being made by Sausage's team, but they want them to believe this baseless stuff that they keep throwing out there that's just like fluff. And it says, repetition does not equate to reality. The court shouldn't fall prey to the illusory truth effect. People tend to perceive claims as truer if they have been exposed to them before. Young's claims should be heard in the family division. Same argument they made before. They, for some reason, think that the divorce court should hear this completely separate issue of business dealings between the parties. And we're going to talk about a little more of that in a second. They make some more crazy arguments. And now, instead of gaslighting, we have the kitchen sink. And again, I'm sure the judge is going to appreciate this no end, because judges, in my experience, are real pranksters who love a good joke and a good pun, and no, they don't. Okay? I've never met a judge that would take to something like this and think that this was cute, because it's what it is. It's cute, and court isn't cute. Okay, this is a very serious lawsuit, and they're trying to make it cute. Shelesh concedes that some of the claims that Young makes are viable. Those claims are best heard in the family division in the dissolution proceeding, and all stem from alleged breaches of fiduciary duty related to waste of the community business channel Red. They keep saying that, but it's not the same thing, and I'll explain why in a second. If the court retains Young's claims, the derivative claim fails because Young did not comply with the derivative statute and failed to plead futility with any specificity. And we talked about previously in the other filings that what a derivative lawsuit is. Just briefly, for those of you who haven't seen the other videos, when an officer of a company, here comes Amelie, my oldest cat. Oh, hey, baby. She's so confused today at like noon. She was sitting patiently waiting by her bowl to eat, and it was like 5 hours too early. But the poor girl, she's so old, but she's so sweet. She sleeps with me every single night. But anyways, if an officer of a company believes that there is some harm being done to the company, the officer would first make a demand on the board of directors and ask them to intervene and stop whatever the harm is. And if the board of directors doesn't take any action, then that officer or that shareholder can then file a lawsuit on behalf of the company in court and basically take it out of the hands of the board since they're not taking any action. And what they're saying here is that Sausage Young, Evan Young, did not make a demand on Sniperwolf to stop the harm that she was causing, by the way. It wasn't some outside force. And we talked about how there's just the two of them. Of course, it's futile. You don't need to have some elaborate explanation. It's plain to any moron to see that if you've got the two of them only who are in control of the company, and she's causing trouble, and she's not following the rules, or she's doing something that's harming the company, asking her to stop, which incidentally, not through official demand, but he did ask her to stop from what I understand and what I read, why would that make a difference if she is intent on continuing down this path of trying to circumvent the company? It's futile. And in fact, in her answer and counterclaims, she herself pled that it was futile to make a demand on Young, Sausage, to stop what they're alleging he's doing. And they said it's futile. Well, so it's futile for them, but it's not futile for him? Moreover, the 4 remaining claims have no legs, and this damn chicken pun is going to be, you'll see, repeated through this thing. It says, moreover, the 4 remaining claims have no legs. This case is a breach of contract and breach of fiduciary duty case. Everything else is excessive, and doesn't fit. If the court doesn't kick the whole thing over to the family division, Shelesh requests that the court pare the claims down and streamline the litigation because 1, the implied covenant claim is redundant. 2, Young did not properly allege an intentional interference claim. And 3, the conversion claim is really a breach of fiduciary duty claim. And 4, accounting is a remedy. Family division claims. The distinction between the counterclaim and the complaint is that the counterclaim's allegations focus on harm to channel Red, whereas counterclaim, meaning her counterclaim, which is, as we've talked about before, a lawsuit within a lawsuit. So she's basically countersuing him within the same lawsuit. And they're saying that she's properly alleging harms to the company, whereas they're saying he's focused on harm to him personally. So they're kind of one and the same, but let's continue. These claims are better left to the family division because Young is seeking to balance the scales of what he claims he is due, not seek redress for harm to channel Red. And again, they're talking like Channel Red is this mega corporation with all of these shareholders and board members and officers. It's the two of them. They each own half. So they kind of are, and in an LLC, which is not a corporation like an Inc. corporation or a limited corporation for those of you over in the UK, they're basically two people who own the company. So it's a much more informal setup. But they keep making it sound like him seeking redress for the harms he suffered somehow has nothing to do with the company. Well, it does, because the harms he suffered is directly as a result of what she's basically done allegedly to the company, what she's cheated the company out of allegedly, and things she's done to take business away from the company. They directly harm him because they split the profits 50-50. So if she's taking away profit that's supposed to go to him, it funnels through the company, but it's ultimately harming him. It's not harming the company, because the company is simply a vessel for the two of them to get their profits. And they're saying, contrarily, a close read of the counterclaim demonstrates that the requested relief is meant to protect Channel Red. A request to protect Channel Red. A request to expel Young as a member and manager in Channel Red because of his breaches of fiduciary duty, breach of the ceasefire agreement, the agreement that they had come up with when he had locked her out and she had stolen some hard drives, and it was basically the truce they came up with prior to the filing of this lawsuit concerning how to operate Channel Red and dissolution of Channel Red. So she, as we talked about before, wants to basically dissolve the company. Of course she does, because then she's free to continue on her own separate path, and basically he gets screwed out of half of the profits that should rightfully be coming to the company based on the brand Sniperwolf that they own and that the company owns. These causes of action are distinct from the family division. So now they're making an excuse of why her counterclaim is good to stay here, but his claims should be sent over to the divorce court, which, you can't have it both ways, people. And they're saying that causes of action are distinct from the family division's charge to equalize and divide community assets. But Young's claims all focus on his receipt of equal profit, an equalization that the family division is more equipped to reconcile. While Young tries to distinguish between his direct claims and those of waste, and waste, they're saying, is fundamentally what he is claiming. He's accusing Shelesh of dissipating joint assets because he claims that Shelesh created subsequent channels to potentially divert and or otherwise detract viewers, thereby depriving Young of his entitled profits by diverting profits and or other monies obtained through the business and operations of Channel Red. Oftentimes, the family division encounters these issues and engages in an equalization process to rectify the alleged misuse of community property during the marriage. So they cite to this case, and they say that the court held that the family court may compensate one spouse for the misuse of community property by the other during the marriage to offset the value of the lost property. And they say it affirmed the finding of waste based upon excessive and abnormal expenditures during marriage. Now, people, these are two completely separate situations. They're talking about waste as in one spouse basically spent off assets that the couple owned together in their marriage. And so the court's trying to equalize by compensating from the community property the spouse who didn't do the excessive spending. That's completely different from this. We're talking about a company. We're not talking about a marital asset. This is a company they formed. They keep trying to make it a marital asset. They each own half. So there's nothing to divide in terms of, it's not like, he owns the company and she's going to get half, or she owns the company and through the divorce, he's going to get half. They equally own the company, which is completely separate from their marriage. And she didn't spend the company's money and somehow deplete assets in the company. She went off and made deals and tried to conduct business completely separate from the company and using the brand Sniperwolf that the company owned. That's not the same thing as I go into our joint checking account and spend $50,000 and now the divorce court is going to compensate you $50,000 that I spent out of the communal assets of the marriage. It's not the same thing. But they continue to insist that, somehow the divorce court should handle this corporate lawsuit. Then they said, indeed, as Meister v. Meister, if a court finds a party committed waste that reduced the value of a community business, Now, this is a completely separate case to the ones we were just talking about. Now they're citing to one that talks about a business. If it finds a party, not a spouse, a party, committed waste that reduced the value of a community business, it may consider such waste in selecting a valuation date for the business. In other words, and now they're completely contradicting themselves because they're trying to have it both ways. They're trying to make this about the marriage and the community property, but now they're going off and they're citing a case that deals with an actual business that has nothing to do with a divorce. And what they're saying is the court found that a party who committed waste that reduced the value of the business, it may consider such waste in selecting valuation date for the business. So in other words, if the assets that are already in the business, one of the parties or one of the owners dissipates the value or causes the value to go down, the court can consider that and can pick a date of valuation instead of today where it's worth less, can go back and pick a date before that partner depleted the value or decreased the value, and that way give the business a higher valuation prior to the misdeeds of the party, and therefore have a more equitable value when deciding what the company's worth. This has nothing to do with a divorce. They're cherry picking to try to cobble together an argument that supports their misguided belief, in my opinion, that this somehow is a matter for the divorce court. Derivative claims, and now they talk about this damn derivative claim thing again. And they're talking about that, basically, that he didn't argue with enough specificity why it was futile to not serve a demand on her. And I think that's just, it's ridiculous because of what we talked about. I'm not going to rehash that again. And, you know, they talk about the demand letter. And again, they themselves said in their counterclaim that it was futile to make a demand. But somehow they think that they pled it sufficiently, but he didn't. And therefore, his claim that there's a derivative claim should be dismissed on that technicality. That's not going to fly, I don't think. Then they talk about the implied covenant of good faith and fair dealing. And they're saying that, and I'm just going to like sum this up because we've talked about this stuff in depth in the other videos. If you haven't seen them, go check them out. I go through and explain in fairly understandable terms, I hope, what all of this stuff means. And they're saying that the parties disagree that an express breach of contract and implied breach of covenant can be identical. In other words, if the contract says neither party will start channels using the brand name SSSniperwolf outside of the company, that's an express term of the contract, versus an implied covenant of good faith and fair dealing, whereas here there's nothing specific. First of all, we haven't seen this agreement, and it's not clear from what I read whether it was just an oral agreement or there's actually a written agreement. It doesn't sound like there was anything contemplating that one of them would go off and start, you know, separate channels and keep all the money for themselves using the brand SSSniperwolf that they both own, or that one of the parties would go off and make brand deals for those new channels outside of the company, which is supposed to be what is conducting the business of the brand. So when we say implied covenant of good faith and fair dealing, we're saying that, well, even though the contract didn't specifically say that she couldn't do what she's done, it's an implied covenant that you don't do that because it's going to hurt the business, and that it's not ethical to go off and take the brand. And I used the example last time. It's like the president of Coca-Cola can't go start Coke on the side and start selling his own version of Coke and say, well, my contract doesn't specifically state I can't go start my own version of Coke. Well, clearly you're using the brand, you're making money off of the brand that the company owns. You can't do that. So she can't do what she's done. I'm just saying that in her view and in Shelesh's view, there must be a factual distinction between the two causes of action, which is an express term and the spirit of the agreement. Spirit of the agreement being things that aren't expressly stated in the agreement. Otherwise, every time there's an express breach of contract, there will also be an implied breach of covenant. Well, I don't recall him saying that she specifically breached a term and that was also a breach of the implied covenant. I think what he's saying is there were terms that weren't expressed, such as her starting separate channels outside the company, that's what is the breach of the implied covenant of good faith and fair dealing. I don't know. So I don't really know what it is that they're arguing here. And again, they say here, however, the implied covenant claim really only applies in limited circumstances. When the contract does not address a particular issue and when one party uses the contractual gap to deny the other side the benefit of the bargain, which is what we're talking about. It doesn't specifically prohibit her, from what I can gather, from going off and starting these channels and making these deals. But it's implied that that's something you don't do because it hurts the brand. And you're not allowed to just go off and make your own money off the brand that the company owns. And they're saying that based on their argument here, that the court should dismiss the implied covenant claim because it's superfluous to the claims of breach of contract, which I don't agree, and I don't think that that's what he's arguing. Intentional interference. They're saying that his factual allegations regarding the element of an alleged third-party contractual breach are as scarce as hen's teeth. Continuing with our ridiculous theme, he simply points to the formulaic regurgitations of the elements that Shelesh had knowledge of Channel Red's contractual relationships and interfered with them. That said, Young did explain the real basis of the claim by negotiating deals behind Young's back and then siphoning off the proceeds. Shelesh has diverted contracts from Channel Red and Young to her own benefit. Unfortunately, they're saying, this responsive revision to the verified complaint is not what it's cracked up to be. Another chicken reference. It is not intentional interference. It is simply a breach of fiduciary duty. There must have been a pre-existence expectancy or contract that the third party breached to state a claim for intentional interference. So what they're saying is it would have to be like specific contracts with certain vendors or certain partners that she breached by making side deals. And it's not clear. And this is the other thing with these arguments that they're making. They're asking the court basically to decide the merits of some of these things when we don't have all of the evidence. This is the preliminary stage. There hasn't been any discovery. There's been no evidence exchanged or shared. And the court doesn't have any evidence other than the allegations made by the parties. They're just supposed to determine whether the allegations are sufficiently plausible that the case should continue. It's not to decide whether the evidence supports the arguments of the parties, just whether it's plausible without having seen all the evidence that the claims are valid. That's it. They're really asking the court to dismiss his claims because they're saying the evidence doesn't support his allegations. And again, this is not the stage where the court makes that kind of a decision. That's usually a motion for summary judgment down the road after the evidence has been exchanged. And then the parties can say, well, based on the evidence we have here, judge, and here it is, the court can see that, the other parties' arguments don't hold water because the evidence doesn't support them. That's when that should come into play. And so, again, they're really trying to litigate the case up front without the evidence. And so I'm gonna skip the rest about these contractual relationships. The last paragraph says, while Shelesh concedes that Young has stated a breach of fiduciary duty, that is best heard in the family division. And they keep talking about how repeating things doesn't make them true. Well, they keep repeating this best heard in the family division, best heard in the family division, hoping that the court will somehow be convinced that that is true and that it should go over there. So they're basically violating their own argument as to why what he's saying should be ignored by the court. The court should dismiss the intentional interference claim which doesn't fit the elements. And again, it's because they're saying that he has to show that there was intentional interference with existing relationships. Regarding the money conversion claim, Young's arguments are dumb cluck. Again, with the freaking... A conversion claim cannot be maintained to collect on a debt that could be paid more. This is interesting because, again, it makes no sense what they're arguing. Young's arguments are dumb cluck. A conversion claim cannot be maintained to collect on a debt that could be paid by money generally. And they cite to another case. They're saying that case dismissed conversion claim by students for tuition because there was no reason why the plaintiff's alleged harm could not be remedied by a payment from defendant's general account, and plaintiffs could not show an obligation to treat the money in a specific manner. So, again, this is a completely different situation. It sounds like they're talking about a college that didn't keep tuition money in like a tuition account, and the court said, well, that doesn't really matter because the university's general account can reimburse the students tuition, even though that money is not specifically in a tuition account. This isn't the same thing, because we're talking about her having completely separate dealings outside the company, having a completely separate bank account that's not controlled by the company, that she's putting the money into in order to keep it from him. And they go on to argue ridiculously that therefore the funds were not subject to any agreement regarding segregation or specific treatment. The plaintiffs did not establish cause of action for conversion under Arizona law. And again, we're talking about money within a company or a university that just simply is not segregated into its own account, but it's still all money within the university. We're not talking about money from somewhere down the street that doesn't belong to the university, and somehow that's where we can pull the money to satisfy this alleged breach. Her dealings outside the company are outside the company. Channel Red doesn't control the bank account that she set up. So it's not as simple as paying money. And they're trying to say, oh, well, she can just pay him what he claims she owes him. You're missing the whole point of the wrongdoing. If you go and steal $1,000 from your employer's cash register, you can't just say, well, I'm going to go to my checking account and I'll reimburse the business the $1,000. Sure, you may have made restitution, but you still broke the law, and it's still a crime. So that doesn't absolve you. So again, I don't really follow their reasoning. And they're saying that it's the same, that allegations about an amount owed to Young. It is not a specific fund. Young's identification of a bank account is not enough to withstand 12b-6, which is the federal rule dealing with when you can dismiss a case. There's no reason why the alleged harm cannot be remedied by payment from Shelesh, and Young has not delineated any obligation to treat it in a specific manner other than he was supposed to receive his portion. That's not a conversion claim. Well, that's not true. As I just said, we're not talking about money within the same company. We're talking about money that she siphoned away from the company, basically, or kept from the company, and put into a separate bank account that the company has no access to. It's still a crime. She can't just simply pay him off now and say, well, there we go, we're all done. And again, they're saying, again, it's a breach of fiduciary duty. The court should pare the case down to the real claims if it decides the case shouldn't move over to the family division. Well, again, I don't agree at all with their arguments. And then briefly, they talk about accounting. And, in his complaint, one of the things he asked for in his request for relief from the court was that an accounting be done, basically to figure out what the deal is with not just the money in the company, but with the money that she's been making on the side. They're saying that the accounting law in Arizona applies to partnerships, but not limited liability companies. I think they're splitting hairs here because, yes, it's a limited liability company, but it's basically a partnership. It's not a corporation in the sense of an incorporated corporation. It's two people owning half of the company. They're basically partners. I think they're doing a little too much nuancing here. It says, if an action for accounting were cognizable by members in an LLC, the corollary Arizona Limited Liability Company Act would provide for one. It does not. And they go on to try to say the court can't read something into something that's not expressly stated within the law. I don't agree that I think his asking for an accounting makes complete sense in this situation, but we'll have to wait and see what the court says. As much as Young hatched the idea, are you sick of these stupid references? I am. Hatched the idea to expand the statute to cover accounting, and accounting here is a remedy, and there's no need for the court to allow Young to expand the proceedings to allow random, non-recognizable claims. Well, I think it makes complete sense, just like asking for a receiver to a third party to come in and take control of the assets so they can figure out what the hell's going on. Makes sense. They themselves, again, in their counterclaim, asked for the court for an accounting and also for the appointment of a receiver. So they continue to fight against what he's asking for while requesting the very same thing as themselves, and albeit not in the exact same way, but the end result is the same. In the conclusion, the entire complaint should be dismissed and tried in the family division because Young does not allege any claims. Again, they're harping on the same crap. Young does not allege any claims distinct to Channel Red. The claims are really all predicated on waste claims regarding the community business. They keep calling it the community business. What they're trying to do is spin it into being community property instead of a separate corporate entity, which is what it is. And so by calling it community business, they're trying to basically fool the court into thinking that, oh yes, well, it's community property. Well, it's not. But if the court keeps the case, the derivative claim fails because Young did not make a derivative demand or pleads with specificity why it would be futile. Furthermore, Young's remaining arguments don't have legs, chicken or otherwise, and certainly not 4 of them. While alleging everything but the kitchen sink may be appropriate sometimes, here the court should pare the claims down to those that aren't simply rooster games. The parties can then focus on the viable claims rather than running around like chickens with their heads cut off. The implied covenant, intentional interference, conversion, and accounting claims should be dismissed. So there you have it, folks. Another absolutely ridiculous argument trying to make this whole thing into a cute little scenario and trying to belittle Evan Sausage's claims when his lawyers have been very professional, in my opinion. The two firms are like night and day. I think, in my opinion, that the court is not going to grant their motion to dismiss. And finally, maybe this case will progress to the next stage and we can stop all of the nursery rhymes and actually get on with real legal business. Let me know what you think. Tell me down below. I'd really appreciate it. Thank you guys so much. Amelie is here to say please like and subscribe so that we can hit 30,000 by the end of the year. And I've got to clean her face because she's got like goopy coming out of her eye. My good old girl. She wants to go to bed now because she knows that she's had her treats for the night. It's time for bed. So let me know what you think down below. Thank you so much to all of our Patreon patrons for all of your continued support. Squirt is doing really well. He had his stitches out yesterday, finally. The support you give us, that helps to defer costs like that. So channel members, Patreon patrons, thank you, thank you. We give thanks on this Thanksgiving for you and for all of our viewers, all of our new viewers and subscribers. Thank you so much for joining us. I want to say thank you to Repzion, who gave me a big shout out in his video today. So thank you for that. I appreciate it. I appreciate you. I have an end of the year video. I actually have 3 videos. This is how busy I've been. I've got 3 videos. All I have to do is record them and edit them because I've got everything done. And I'm going to get to them hopefully this coming weekend and get caught up here. And then I'm going to do a very special end of the year video. But in the interim, love one another. Take care of yourselves, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.